Good evening and good afternoon. This is Attorney Vincent Davis. We're here for my office hours. At one point, we did have Miss G in the green room, but I don't see her correct right now. But one of the things that she wanted to talk about today was trials in CPS courts and ever changing trial um, landscape. And I think she wanted to talk about evidence and what should be done with evidence. So during the case, usually your attorney is always sending out and getting more discovery. Hold on, that's Miss G now. Miss G, I'm live on the phone. I mean, live on the
I
internet.
I know, but it logged me out, so I need a six-digit code.
I don't have the six-digit code.
It's on your email.
All right. Everyone hold on just a second while I get a code from Miss G. 3448.
No, don't say that. I hope they don't hear you. Okay.
Hold it, I'll put myself on mute. Hold on,
Okay, hold
folks,
on.
while I get
Oh,
this. Okay, Miss G is logging in now. Somehow she got logged out of the system. So as soon as she comes back, she's going to start asking me questions, which I hopefully can answer for everyone. And also, if you have questions during the show, go ahead and post them wherever you're looking at, Facebook, YouTube, etc., and post your question, and we'll try to answer it during the show. Okay, Miss G, what are we doing this evening?
Okay, so our discussion this evening is about right before CPS trial, the evidence changes everything.
Yes, it can.
Well, we discussed this today, so I need you to explain to the viewers what we mean about that. When you find evidence at the last minute right before trial that your client didn't share with you from the beginning of the case, how dangerous is that to the case?
Well, it could upset the apple cart, but I do have a fair amount of experience doing these cases, and I can always do a workaround or try to do a workaround on a case, um, and hopefully try to get what the client wants, even when negative evidence is discovered in the case. A lot of clients get freaked out by it. There's nothing to really to be freaked out by. As one of my mentors once told me, Jerry Spence, there's always a way to try to work something out. And in the case that problem that came up today, there's a way, and I've thought of two or three alternatives so far. But I'm going to discuss with the client tomorrow about alternatives to what our original plan was.
Right.
So
But
nothing is ever fatal. Nothing is ever written in stone. Um, so there's no reason for freaking out.
right. But also, I guess my thing is, why don't you explain to them how important it is to be honest with your attorney? I mean, somebody you hired, not the CPS attorney. I'm talking, not the public defenders. I'm talking about when they hire an attorney, how important to be honest with them, because again, it will take you more time to think of a new strategy than the old one that you already had
Hmm.
throughout the case to win the case, right?
Yeah, yeah. I mean,
It makes it difficult.
It's optimum that you're always honest and you're always open and forthright with your attorney. But it's sometimes it's difficult. You know, you don't know the attorney. You don't know if you can trust the attorney. you're embarrassed. Um, you don't want to face ridicule or whatever. In my practice, I don't judge and I don't ridicule. There are situations in life for everyone that always come up or that have happened. So what we need to do when things like that come up, we need to take a step back and give it some thought. Now, I can tell you this, Miss G, I've been thinking most of the afternoon, researching and thinking of different alternatives that we can use to still get what we want in the case. So everything is not lost forever.
And how
Sometimes,
important?
sometimes it takes a little bit longer than you would want to expect, but we can always try to get you to the promised land. Go
Okay.
ahead. What were you going to say?
How do you? What would you tell parents to prepare for the trial? For example, if they're on the stand and they're being cross-examined by you and the opposing party, um, how important it is to stay calm and to think before you open your mouth, and how dangerous it will be during that moment when they will do anything to destroy the parent on the stand.
Right. Well, let me answer those one at a time. It's important that when you testify that you do so honestly, clearly, and you only answer the question that is asked. So, Ms. G, I'm going to pretend you're the lawyer and I'm the client on the witness stand. Ask me, the question will be, when is your birthday? Go.
When is your birthday?
Well, my birthday is July 7th, 1958. Now, please note that before I answered that question, I took a breath, half a second, full second breath, before I answered the question. That breath, that period of time allows my mind to catch up to the question and realize if the question was a trick question or what question is the lawyer asking me. So you always got to take that break and, before you answer the question. You don't want to delay too long because you don't want to give the trier of fact, the judge, or the jury the idea that maybe you're taking too long to answer the question because you're not telling the truth. Okay.
Okay.
So, second thing I mentioned, only answer the question that you asked. I didn't say July 7th, 1958, and I was born on Johnson's U.S. Air Force Base in Yokohama, Japan. I didn't say that because that's not the question you asked me. You asked me what was my birthday. Where were you born is another question. So a lot of people would have said July 7th, 1958, Johnson's U.S. Air Force Base, Yokohama, Japan. And you're doing that because you think you want to be helpful. Please, if you're on the witness stand in a trial that I'm doing, don't be helpful. Okay? So being helpful is going to cause problems. Because sometimes, people will think, well, that's not the question the attorney asked. And why isn't he answering that question? And then in their minds, that doubt comes along. Oh, is he telling the truth? You know, and there's all different types of questions and answers that where you can see where that can go wrong for you. So only answer the question you are asked. If you want to say something else, you will cross your fingers and hopefully your attorney is experienced enough to do a follow-up question. Okay? And that particularly happens during cross-examination when an opposing attorney is asking you questions. Hopefully, your attorney will know to follow up when it's your attorney's time to ask questions. Don't try to cram everything into 10 seconds. Trials take long. Be patient. Let the attorney or your attorney flesh out the answer. What I tell people to do when they're answering questions truthfully and just answering questions that they're asked, um, to paint a picture, all right? To paint a picture of something if you're describing an incident, all right? But don't just start talking and blabbing. Go ahead. Miss G is muted.
Stacy asked a question: if something is on a video, can it be excluded from evidence if it's not the entire interaction?
The answer is yes, um, but that doesn't mean it's guaranteed to be excluded. Now, Stacy asked a question. It's a legitimate question. The problem is the answer is not black or white. It's not red or green. There's a lot of gray in that question. So she asked a question, can it be excluded? Well, yes, it can. Can I win the lottery tonight? Well, yes, I can. You get it? So that's not the right question. She'd have to give me a lot more facts and details about the case or about the background of the questioning. And then the attorney, hopefully experienced in evidence, can either help get it in or keep it out. A lot of people don't realize this, but my mentor taught me this more than 20 years ago. The key is not the black letter law. The key is, do you know evidence good enough to get in what you want and keep out what you don't want? Okay, I'll give you an example. Yesterday, and I've given this example before, a minor's attorney made a motion to exclude the testimony of her client from trial. She doesn't want to put the minor in the witness stand. But the evidence that she proffered, the social worker's opinion, the social worker's reports, logs, and the caretaker's opinion, all supported her motion. But I argued to the judge, which is the proper argument, all of those people do not have the foundation or the experience to testify about whether something would be emotionally detrimental to a child, right? You're just giving an opinion that has no foundation. It's just mere speculation. And I argued, as I have before, is if you want the judge to keep the kid out, you have to prove that it would be detrimental. Well, how do you prove that? Well, usually you get a licensed therapist or psychologist that has evaluated the child, who can then write a letter or a declaration saying, hey, this kid really shouldn't testify. The kid, it would be emotionally or psychologically detrimental. But in a lot of cases, you don't get that. People don't argue what I argued, and the kid is excluded from testifying. So you got to know the evidence. You got to know the rules of evidence. You got to know how to get things in, and you got to know how to keep things out.
Okay. What if you just discovered, for example, that a client tampered with evidence and lied about it, and it's going to make it matters worse for her?
Well, one of the first things you want to consider is you don't want to expose her to any additional, or him, to any additional criminal proceedings, right? That's number one. Number two, you have to review the evidence with that client to find out, under what circumstances all this happened, right? Sometimes you come across things and you just assume that you assume the worst. Well, not that's not necessarily true.
Hmm.
Sometimes there's an explanation. So you want to then start thinking about alternative strategies.
Hmm.
Alternative strategies are only limited by your imagination as a lawyer, doing these types of cases. There's always alternatives. Sometimes those alternatives will take longer, but there's always alternatives.
Okay, so in a criminal investigation, um, right? Again, during a criminal investigation, that's also a CPS investigation, and the parent admits to tampering with evidence, for example, right? And then right before trial, that's when everything comes out in the open. Um, I believe you mentioned earlier to me that even if the district attorney refused to take the case and drop the charges, the judge can open the charges.
No, no, the judge can't. The judge can refer it for
Request
requests. Yeah,
request from the district attorney. They
and
have
if something happened today, generally, the district attorney can has 3 years to file a case against you.
right,
So
even if it's a
what
different
happens?
district attorney.
Yeah, what happens is elections come up, and you see this on the news sometimes. And District Attorney A lost the election, and now it's new District Attorney B, and
Right.
he or she decides, oh, I'm going to file a case against this person, even though District Attorney A declined to do that. Being charged has a lot of politics involved with it, and sometimes you have to figure out through talking with lawyers what's the best thing to do, right?
Hmm.
And sometimes the best thing to do is not upset the hornet's nest because you'll get stung.
Hmm.
I'm a firm believer. You remember when OJ was found not guilty,
Yes.
uh, and then he got in a bunch of trouble in Las Vegas for some memorabilia. When you get past a criminal case like that, where it's very shaky, one of the best things you should do is like lay low. You know, don't talk to people. Don't go out there. Don't put yourself out there in public because things will always or can always go awry. In that second case where OJ was convicted and did go to jail, a lot of people were speculating that it was payback for him being found not guilty regarding Nicole Brown Simpson. So you never know what people are thinking, what they have in their heart or their mind. But if you are able to escape prosecution, one of the things that you need to consider is laying low, right? You know, when people reach the top of anything in our society, there is a proclivity of other people to start bashing them.
Right.
You see it all the time in
Yeah.
politics.
People judge not knowing the whole story. I personally believe he's innocent. Me personally, I've always believed he was innocent. It was the people she hung out with that should be questioned. But again, um, it is what it is.
It
And some
doesn't matter. It doesn't really matter what he was innocent or not. He wasn't using a good strategy of staying low and out of the
yes,
public eye.
yes,
You know, and I can easily say that people that become president, no matter what they are, Democrat, Republican, the other side is going to criticize them about everything they do, anything they do. They can never be right. And it's just what our society does. We take pot shots at the people that reach the top.
judge lest you be judged.
There you go.
And that's what I tell people: don't judge, because nobody knows the circumstances of others, and we should not just call people crazy and stupid when you really. How can I say this? My mom and dad used to say, "Don't throw rocks when your house is made of glass."
Right. That's an old saying.
Yeah.
That's an old saying. It's so true.
Yeah. My parents, good people, good people. Um, but I guess the whole purpose of this video today is to prepare people for trial and how important it is to provide your attorney with accurate information. I talked to so many people today where they're afraid to speak with me because they ask, well, first of all, they ask, is this going to be confidential? Are you going to go tell anyone? I'm like, no, you're not supposed to. So I'm not sure why they keep asking that. I'm
Because
also,
people are scared and concerned. They don't know you.
no, no, no. Yes, they do. They know who I am. Um, I also get other calls from people that are pretending they have a case and they don't have a case. I don't know if they're social workers. I don't know who they are. I don't know them either. And I had a couple of people laugh. They were telling me they have a trial coming up, and then they stop talking and start laughing. And I'm waiting for them to actually tell me what's going on. And then they say, "So what are you wearing?" Or "How long have you been doing this?" And "Do you know Mr. Davis very well?" And they start asking some irrelevant questions that has nothing to do with CPS matters. And of course, me being the blunt person I am, I tell them either tell me what's going on with your case. If you need help, if you don't need help, don't bother us, and we have other people that actually need help, so you're wasting my time. And usually when I tell them that, they hang up the phone on me. So I don't know who they are. This is not just two. I actually wrote notes about that. There's like 7 people I spoke with today that did the same exact thing. So again, I don't know what is happening in the world right now, but times are changing, and you don't know who you're talking to on the phone. You don't know who's calling you. um, they're discussing some weird stuff, and I don't even know what to believe anymore. Are you really a person that needs help, or you're just playing games? It's really unfortunate, but if you need help, serious help, and you need our help, don't hesitate to call our office. But if you're playing games, just grow up. Please grow up. Life is too short. You might not be around in the next hour. No one knows what's going to happen. So do good in life, do good with people, because the ugly you do will come and haunt you whoever you are. And I feel sorry for you people that do this. I really feel sorry for you. But when you reach me, you better believe I'm going to tell you to your face the truth about your actions. So if I were you, I would think twice, because I don't have time to waste, because there's other parents that need my time and Attorney Davis's time. And that's the truth. So a lot of you guys watch the shows to write stupid comments, or to, to use information that's not true. Um, I don't know. I didn't even know anymore, Mr. Davis. I don't even know who I'm talking to anymore on the phone. I really don't. What's your feedback on that? I'm kind of fed up with it.
I think that you're worrying about something that you can't control,
True.
and you letting it bother you.
It doesn't bother me like I used to before. Now I just feel sorry for them. But again, it's becoming too much. I don't even know if somebody's paying them to do that. I really don't know. Somebody must be paying these people to waste our time. You understand what I'm saying? To waste
Yeah,
our time.
but it really doesn't matter, Miss G.
I know.
Doesn't matter. So
I
let's
know.
not even talk about it.
Yeah, you're right. You're right. So I guess if you have a
Anything,
trial coming up, prepare for the trial effectively with your attorney. If you have any questions, I guess you can call Attorney Davis. Um,
what I think would be valuable is for people that have trials or contested matters coming up, that they give you a call and book a consult with me, see if I can help them. Because a lot of times, based upon my experiences, um, I have a lot of insight, not because I'm a smart guy, but because I just have so much experience doing these cases.
mhm.
So I would welcome to have a consult with you, and give you ideas that you can share with your attorney um, for upcoming trials or consults or contested hearings.
Right.
Any other questions you have for me, Miss G?
Yes. Do you, if somebody is being represented by an attorney, do
If
you
what?
need, if someone is being represented by an attorney, do you need a consent that they can speak with you?
No. If they're speaking with me for a second opinion, no.
Okay. So that answers my third question. My fourth question is, can, not can, that's not a question. How can I say this? If a social worker, right before trial, comes up with new evidence against the client, which is always happens, they always wait for some reason at the last minute on trial, like right in trial. Oh, we have new evidence, right? The, you know, the child told the therapist that mom told them not to trust the therapist, something like that, right? So all of a sudden they have this new evidence. If this happens right in trial, right, what is your feedback on that, and what is your action in court when something like this happens?
Make a motion to exclude it as being untimely, or make a motion to continue so that you can investigate and get witnesses that may contradict that new evidence.
Good. So you can make two different motions, right?
Well, usually I make them in one. Judge, exclude it, and if you don't exclude it, please give me a continuance so I can conduct an investigation.
Okay.
That has happened many times in my career, and I'd say
Fantastic.
95%
Mhm.
of the time, the judges say, I'm not going to exclude it, but I'll give you a continuance. That just happened in a case this week.
What? Why do they use that excuse every single time?
Use what excuse?
That the therapist said,
It's the best evidence against you.
right? But sometimes I wonder if they pay the therapist, or the therapist actually works with them, or, I mean, it doesn't make sense. That's like in almost every case, it happens during the trial,
Well, I wouldn't say it happens in every case, but it does happen a lot.
a lot. So in most cases, it does happen. That's a lot. So they always use the therapist part, but the parents always have to go to the CPS recommended therapist, right?
No, wrong.
Okay, well, the people I spoke with, the parents, they said that they had to go to a therapist that the social workers recommended.
Okay. Sometimes I hear that order being made
Hmm.
by a judge, and it's my opinion you should probably appeal that order. But a lot of times the judge doesn't tell you that. Social workers give you someone that they will refer you to. They may be in bed with the social worker or not,
Hmm.
but you can always pick your own therapist, your own parenting instructor. I have a case right now that was texting with the client today, where the social worker insisted that he go to a certain therapist, and he had heard just by going to parenting classes from other parents that never go to the social worker's therapist. Um, pick your own. And he said the social worker told him he couldn't do that. He said, "Yes, you can," and send her an email to confirm what I've told you. And she never responded, and he continued with his own therapist. And now he was recently granted unmonitored and overnight visits with the kids. So he's, steps away from moving back into the home with the kids and the mother. And he didn't use a CPS approved therapist. If somebody is a therapist and they have the qualifications, the law doesn't stop them from you using them in their case. And that
There's a
becomes increasingly important when you have like psychological evaluations.
mhm. um another, there's, I have two more questions. Well, I have something to add to that. um Parents, be aware if you're fighting against another parent, for example, and say that CPS workers place the children with their dad temporarily or their mom temporarily, and then the other parent is being prosecuted for shit they didn't do. And the dad takes the children or the mom takes the children to a therapist that she or he knows or is related to his new girlfriend. Be careful with that because oftentimes they're going to do what that parent is telling them to do and say, and this happens a lot. And when the parent notifies their court appointed attorney that this therapist is related to my ex's girlfriend or my ex's new wife or whatever the case may be careful with that because these new evidence will come during trial. So you need to be able to address, your attorney needs to address this ahead of time. Am I right, Attorney Davis?
Absolutely. The
Yeah.
more that you can address ahead of time, the better.
Correct. So be aware of that. Um, Secondly, when when a parent is coaching, when one parent is coaching the child, that if you don't lie or you don't say this, you're never going to see your mother again. Example, right? And then in trial, the parent that's doing this to the child wants to speak out, and like the child wants to be able to talk to the judge, for example, like a 10-year-old or 11-year-old, but then their attorney refuses for them to speak to the judge, um, because the kids are stuck in the middle of two parents, for example, right? They want to say the truth but they don't want to hurt the parents, but the judge is not allowing that to happen. They're not allowing for kids to speak, even if the child is 15 years old. They're not allowing themselves to listen to these kids and what the kids are saying. So as you being the attorney, for example, somebody hires you, you being the attorney, what would you do for you to give the child a voice?
The child a voice?
Well, be able to allow the kids to speak.
Well, you can't speak.
I guess.
You can
How
come
can
and
I
be a
say?
witness.
Witness, right? So how can you?
You can subpoena the child.
So you can subpoena the child, right?
Hmm.
And then that child's attorney is going to object.
So I just told you that about that happened in another case. They can object all they want unless they have evidence to prove that it would be detrimental for the child to testify. They're out of luck.
Okay.
Child has to testify.
So that's good to know. That's really good to know. I
But
hope
you
you're
you have
listening
to
out
have
there. The
you
parent I spoke with today, Mr.
oh,
Davis, just answered your
you
question.
you have to have a little bit of a backbone though, because what happens is, in my opinion, there is a unspoken rule that we don't want to take children's testimony. Now that's not the law. So sometimes you subpoena a child, and then everybody's putting pressure on you, sometimes off the record, and trying to convince you not to make the child testify. Now, if you succumb to that peer pressure, oh well. But if you don't succumb to the peer pressure and stand your ground, the child's going to have to testify no matter what. Will the judge be mad at that attorney? I don't know. There's a chance. I can't tell you how many times I've been in a courtroom trying to make a child testify or trying to get a child on the witness stand, and how much pressure is put on you not to do that. So you got to have a little bit of a backbone and stand your ground as the lawyer to make them put the child on. There's a handful of arguments children's attorneys always use to try to prevent keep the kid off the witness stand. I've heard most of them. And like in the case I just told you about this week, the minor's attorney made a second motion She already lost the first one, made a second motion to keep the child off the stand.
Hmm.
And because I knew what the evidence was, I can keep evidence in and keep evidence out when I want. Um, the judge ruled in my favor. Has the judge always ruled in my favor in those situations? No. I would say maybe 65, 70% of the time. So there's no, everybody wants to know the black or white, yes or no answer. There is none. All right, there is none.
I have a parent that's watching right now. I actually saw his text message. He said to me, I spoke to him the beginning of the year, February. No, sorry, the end of January, January 25th to be exact. Um, he texted me last night, said he's ready to hire. Now we're in June. No, what am I saying? We're in May. Um, so, anyways, I had Yolanda prepare the agreement for him, and now he's saying that he wants an aggressive attorney. And his TPR is June. I forgot the exact date, but that second week of June. Um, is terminating his rights. So I told him, I said, he can get you for an appeal, you know, to file the appeal for him, or, you know, review his case and to see if you can redo the trial, right? Depending on what happened or didn't happen in the case. No? Well, you'll make that determination. Whatever you would review in the case, you might be able to do something for ineffective counseling, blah, 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 right?
Has he had his TPR hearing?
It's in June, I said.
He doesn't want me to try to stop it?
No, he does, but he said he wants an aggressive attorney.
Oh,
I
he
said,
doesn't think I'm an aggressive attorney?
no, 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 wait, hold on. No, that's not what I said. So he wants an attorney to go to court and say, "You sons of, you know what, my client is innocent," and that doesn't work that way. And I tried to explain that to him. It's just, you don't win by using aggressive force in court. You win by specific strategy to help you win. Am I right?
That's my theory. All right. And I've known attorneys over the years that would get on top of counsel table and stomp their feet. The longer I know them, the less they do that, because it's not effective in the science of persuading another human being of something. You know, what I ask people is, if you were trying to convince your wife of something, would you yell and scream at her? If you do, your odds of winning are probably going to be low.
You don't insult her either, even if you're not screaming.
And then if you take the other route and try to persuade her, you know, your probabilities of success go up. It's only human nature,
Hmm.
you know.
It's easier said than done, Attorney Davis.
I know that's why you got to have a lot of experience, Miss G.
Mm. Yeah. Yep. Yep. Yep.
You know, there's someone in Southern California who used to work for me who is a doing CPS cases,
Mm.
and I saw him recently in a court case where he had changed his style completely. And we're still friendly, we talk. And I mentioned that to him. You know what he said? I've been watching a lot of your videos.
I know who he is,
So I mean,
but he's
everybody,
still he's
everybody,
still
everybody
taking.
wants everybody wants that aggressive attorney, and they don't know aggressive what aggressive means in the courtroom.
Exactly. Exactly. And don't expect Attorney Davis to show up not knowing what the hell happened. A lot of people think they can hire you, and they're going to lose their parental rights, and you go in there and you stop them. You completely stop the adoption immediately. It doesn't work that way. Um, mm. There goes that magic wand again.
right? I don't have
Doing
a magic wand, and if a lawyer ever tells you they have a magic wand, run away as fast as you can. I got a call this week. Somebody told me, "Hey, I got, I have a lawyer who I want to hire, and he guaranteed me he'd get the child back to me.
Mm.
Can you guarantee me that, Mr. Davis?" And I said, "No, it's illegal for me to give you that guarantee. But if that attorney is guaranteeing you something, have him put it in an email or text that he guarantees you to get the child back." A few days goes by, the potential client calls me and he says, funny thing, that attorney won't put that guarantee in writing. And I said, well, what does that tell you? Right? That the guarantee was a lie to induce you to pay him money. So, I can tell you things that I can do and I can try to do, but no attorney can ever guarantee you a result. It is illegal in all states, including California.
I want to. May I say something real quick? I have a client. I'm sorry, a parent. He said I spoke with the regional program center on looking for an apartment to move with my girls. Right. Um, his TPR is in a week. He's focused on getting an apartment to move in with his girls rather than stop the adoption. I just wanted to say something for this parent.
Unless there's some other
This
strategy
is
or
the
facts
parent
going
that wants
on,
the aggressive attorney.
you might be doing the wrong thing, my friend. Just an opinion based upon almost 40 years of experience. But why listen to me?
Well, listen to me too. I
Yeah.
mean, I keep telling them don't focus on the wrong thing. You need to be able to stop the adoption so you have a home for your girls. If
If
you
you don't,
don't,
if you don't stop the termination of your rights, it doesn't matter where you live,
no, it
because
doesn't.
the kids won't be with you.
Right. So you're focused on that, then stopping the adoption. See,
You know,
that's I.
many times I tell people you're focusing on the wrong thing. There's an order of things that you should be considered, one, two, three, four, and planning for. If I tell you focus on one, two, and three, don't come to me with, well, I really want to focus on four, five, and six. You can do that. It's your case, but you're lowering the probabilities of your success. And if you get your rights terminated and the kids are adopted, it's not impossible, but it's almost impossible for you to turn that around. And of course, it's a lot more expensive.
It is impossible. If they move to another state, then the case is closed and
It's
adopted.
it's not impossible. There's a little grain of rice that you can still do something.
Okay, that's good to
Okay, but
know.
but it's highly unlikely. There's a difference between highly unlikely and impossible.
Right. But what I'm saying is a parent that lost their parental rights 5 years ago and they want to get their kids back and they don't know what state the kids moved to, who adopted the children. I don't believe there's a possibility in this one.
I know you don't, but you're not the 40-year lawyer either.
Okay, I understand that. I understand that. But what if the foster parents move to a different country? What are you going to do? Fly to Zimbabwe and find them?
I don't know. It's fact specific. And you'd be surprised that sometimes that happens. A foster parent adopts, you don't know where they are, but you'd be surprised how many times you know where the foster parent is.
That's if you know. But if you don't know, if you know, there's a possibility. But if you don't know who the foster parents is, that's what I said.
Have you ever heard of private investigators?
Yes, but the parents cannot afford all that.
You don't know that.
No, I spoke to them. They can't afford hiring
Oh,
a private.
you're talking about a very specific
Yeah,
person.
yeah,
Oh,
a very
okay.
specific person. 5 years ago, kids adopted. They don't know if they moved to another country. It was a couple from, um, what's the name of that? Oh my God, Venezuela. It was a couple from Venezuela. And 5 years ago, they were told that they're going to move to Venezuela. So the social worker told the parents that the foster parents are going to move to Venezuela. They tried to find out their names, anything about them. The social worker said it's confidential information. Nobody can find out. They tried to get their court records. Nobody can give them the court records. It's sealed, because there was an adoption, final adoption. And I guess that they're still fighting to try to get their kids, but they don't even know if they went to Venezuela, if they went to Cambodia, who knows, if they went to New York, Boston, they don't know. They didn't even know if they went, like the father was crying. He said, I didn't even know if they went to, you know, the North Pole. So how can we find them? I told them about the private investigator. They said they can't afford that. So this is not a $5,000 case anymore. This is extremely high conflict, extensive man hour, right? Attorney hour invested in something like this. And it might take a couple of years to solve. Am I right?
Mm-hmm.
So if you guys want to fight for your kids after the fact, it's a lot easier to fight for them before it gets to the TPR, termination of parental rights. It's a lot easier and better for you as a parent to get them before they terminate your parental rights. Am I right, Attorney Davis?
You're right.
He doesn't tell me that in the office. Usually when I talk to him, he never says I'm right about anything.
We'll edit that part out. Don't worry. Don't worry. We'll edit that.
I
Grace, are
know.
you there? Is
It will be
producer
out
Grace
tomorrow.
there?
Tomorrow, I'm going to be wrong in everything.
Grace, give us
Everything
an
is gonna be
outro,
my fault.
please,
Huh?
before Miss G goes crazy. Give us an outro, Grace.
A vivid picture is encrypted in your mind as the critics get in line like they're witnessing a crime. But then you notice there's a shiver in your spine from the feelings of discontentment and bitterness combined. Heartbroken when you listen to the judges, another kid's innocence corrupted. And if you go against it, it's destructive. Consider this predicament the toughest, but we believe in a system fit for justice. Child Protective Services only pretends to save it. The one solution for this is worthy of instant praises. 30 years of experience with relentless cases. Allow me to introduce them. This is Vincent Davis, defending you when they don't think a mother fits the role. Is it juvenile dependency or government control? Observe the pain in their eyes. It's time for us to realize we are the
last ones left. Put your